Objection before your lordships. One is PET, another is SANSKRIT. Both these subjects were segregated in this should be segregated from one other so that it will be easier to decide the list.
Which to be segregated from which? Item number 3. The serial number 31572 by 2025. This is to be segregated.
31572 of 25. That is segregated. 31572 of 25.
Segregated, but this is also taken up in the interim model. We selected and you are not getting appointment. That is
second one is Sanskrit.
All others are, I think, Sanskrit.
First and second are Sanskrit.
The others are Sanskrit. First and second you can take Sanskrit.
First and second is Sanskrit.
Sanskrit. That Sila is submitted. Yes.
Second matter,
I am in the PET matter. Can it be taken up tomorrow, madam? Or tomorrow, PET matter tomorrow. It is also equal. Are selected. Tomorrow, all right? No, that's Sanskrit. That's Sanskrit. That PET matter, the segregated matter. Segregated matter. That is the theory. That is a small matter can be disposed of. But tomorrow, if not today. After seeing this, then we can take up your matter. No, this will start today. Let them start. It has no nexus, I think. If somebody will argue, if somebody will try to take up these two batch of cases, then I have nothing to say. But the PET can be disposed of independently.
we can take up Sanskrit.
Sanskrit may be included, so therefore I am submitting tomorrow. You just started. Let us see. You keep it. Even today. Also with this only we can. It will be on the same day whenever this is posted that way.
In second item,
Second item is the lead case. The second item is the lead case. Second item is the lead. 16242 by 2020. 14501.
16242.
Yes. 16242.
Second item.
Avinash Mishra.
Avinash Mishra. And my lord, another in that petition, I am the petitioner. My amendment petition, but IA number 20213 of 25 is pending.
What is that amendment?
Only to insert the apart from my other only ground to for seeking direction to for preliminary exam, which has not been done as admitted.
That we have filed our objection to that.
There is more than
That we have filed our objection. That objection may be
more than 5 times in the
File objection.
5 times.
Oh, yeah, objection.
The state has filed, so also we, the private parties who have appeared in that final exam, have also filed an objection because this comes after that other order. So they are basically, it's a ground of fence sitter.
Objection which is my friend has not been solved.
No, sir.
Not answered, not so.
But what
The objection filed by the commission has been solved.
from me, madam,
Yes.
what I suggest is, let us allow that application. And or we can take up that application as additional pleadings only, so that again amending and other things, it will go beyond January. That will not serve anybody's purpose.
Yes.
So as it is, if you all agree, the application along matter itself can be taken up. The application can be taken up along with the main matter itself.
Yes.
That everybody is understanding.
Yes.
That the application also will be heard along with that. But there is one risk.
That can.
Supreme Court says, where amendment is sought for, court has to pass an order on that. Permit the amendment of the pleadings so that parties will move. Only thereafter court should take up the main matter is the version. But all of you agree. I can make an exception saying that the application will be treated as part of the petition itself.
Now the difficulty will be, you want to change the prayer of the petition. If the prayer is now want to make, if that will be argued, it will be difficult for us to answer. That matter to take into consideration. Ignoring that amendment petition, also may
That is the formal in nature.
One way to it. One way to it. It's been kept as an additional pleading there. We also filed an affidavit replying to that additional pleading. So because
Everything.
and so that our reply on merit to that amendment is also on record and everything is heard. That's just it. Because the main approach is that if something new is coming.
That will change the very structure of the petition.
Yes, exactly. Change the natural character of the case.
Well, can I interrupt your lordship? Well, I am also an applicant with a writ petition bearing number 31675 of 2020. What the amendment, what is being suggested in the lead case, the so-called lead case in the WPC 16242 of 2025, that is also there as an impugned action in my case with prayer properly structured, where your lordship on the day one issued notice to the state panel council asking him to file counter, fixing the date originally to 27th of November. Till today, my lord, there is no counter affidavit filed. So even if your lordship allows that IA, which he has filed by way of to bring certain facts by way of amendment is allowed, that is only to make the said case at par with my case, which is already there. So there is no meaning.
In your case, already such a pleading is there. You had no such prayer earlier. Now you have made the application. I seeking permission of the court is one thing, but that prayer is already made. Yes. What Madam Pami says appears to be sensible. Yeah, since that prayer is already there in one of the
But
petitions.
the writ application has been filed recently after all these things, when this matter was argued, thereafter this was filed.
But it is
But again, I have to give reply, that it will take.
then there will be no end to all this. Yes.
No, also may take up that matter, but Mr. Kata is suggesting that maybe.
When your lordship issued notice in my matter, such an understanding was also given by my lord's senior counsel appearing for the department, that we will be filing the counter. That is why the short date was given.
If I say like this, the prayer which now he wants to introduce would not much come in the way.
Yes.
Since such a prayer is already made in one of the petitions.
Yes.
So that time can be saved.
Yes. And your lord,
Our argument is that
and it is a
major objection, whether to his amendment or to Mr. Mahanti's case is this, that both of them somehow lack the locus and they have not come with clean hands before your lordships. So if that is also taken as a preliminary ground and we succeed in showing that
The petitions will go.
our objection also to this prayer is basically that.
Your objection to amendment may not fail. You might have taken that, but generally, such contentions are taken to ensure that the petitions are dismissed in limine.
Yes,
Without much discussion.
yes, your lordship.
But if that contention will remain, whether I allow that application or not.
Yes, your lordship.
So,
In fact, that might be the first thing which needs to be adjudicated to see that whether the court will at all be interested to get into the
whether the court will take up the matter or not.
Yes, your lordship, because it's a court of equity. Those three principles always will stay.
my lord,
That was a good.
so far as all these matters are concerned, this is squarely covered by your lordship's judgment.
Yes.
Rendered in the case of
No.
teacher, where, my lord, the advertisement condition was violated by not holding that preliminary examination, even if the valid candidatures were more than 5.
Ratio was
Yes. So same thing has been asserted over here. And my lord, the counter affidavit filed by the commission in the other case reveals on affidavit that in the case of Sanskrit teacher as well as PT, the total valid applications were more than 5 times of the advertised vacancy, but still they decided to
Not to hold the.
not to hold the preliminary examination
Yes.
by a single order, which your lordships have deprecated. In the single order, they have both for Hindi, Sanskrit and PT. The commission decided to hold the preliminary examination. Violating the condition
There is a difference between that case and present case.
We have two important judgments of the Supreme Court. That your lordships, the judgment in the Hindi matter comes at the behest of a petitioner who was vigilant about his right, comes immediately to the court.
Exactly.
This petitioner here, his petitioner sat through the hearing. Now when the judgment comes and finally everything is over, he comes to the court. Your lordships, that judgment is confined to Hindi. Even the latecomer cannot say that, you give me the same, we have a judgment to that effect. And as per Mr. Mahanti's client is concerned, he's only come yesterday.
After knowing the fact that he has not been selected.
selected candidate.
He comes when there was a complete notification showing that we are not going to hold the preliminary exam. He goes,
That cannot be.
participates in that examination, final examination. Document verification notice comes up. He still does not come to the court. He comes after that judgment is declared. So there are many locus points. I think that unless that is not crossed over, they cannot come up clarity with that Hindi judgment. That petitioner was a vigilant petitioner.
My case is not.
He attends it us. And he also makes
Not late for not late. At the same time, Hindu case.
We apply that.
I'm calling this matter tomorrow.
lordships.
From tomorrow we start.
Yes, ma'am.
Tomorrow, your lordships.
How many cases are questioning tomorrow? Only this matter at 2 o'clock. Only this matter.
Lordship, three matters similar. Same issue. They have not conducted three, item number 3.
We'll hear it tomorrow, na?
Yours, all the matter come. All the matters will come from
All these matters.
will come tomorrow. But each matter which may done clear. Is item 3. I got the yes. I got the last was mentioned that inside this it may be second. No matter.
No, segregated for tomorrow. But called along tomorrow. Yes. Let it come this matter. Yes. But tomorrow won't come.
In that PET matter,
16242
the PET matter will file out counter. PET matter will file out counter, but that has not been tagged with the file. The account, don't call it.
Registry to put the count.
Well, in you copies.
Yes.
Counter copies. Tomorrow I will not, you can't say that copy is not sorted.
I will solve.
Well, let them file the counter which your lordship directed in 31675.
How can I direct? I can only say if you want to file, it's not. Okay, she may argue without use of your counter. Yes.
Where Article 57 is covered by your lordship.